I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today what I'm going to talk about are the basics of cross-examination in a Connecticut divorce case. So there's two main types of testimony in a court trial. That is direct examination and cross-examination. Direct examination is when a lawyer is asking questions of their own witness. So it's the witness that they call to the stand. They are asking that person on the stand, they are asking them questions on direct examination. And there's a rule of evidence that says you are only allowed to, during direct examination, so when a lawyer is calling their own witness, you're only allowed to ask non-leading questions. You cannot ask leading questions, and leading questions are questions that suggest what the answer is. So there's a couple exceptions to that. You are allowed to ask leading questions on direct examination if the witness is an adverse witness. So if it's the other party in a case, if it's the opposing party that you're calling on direct examination, you can ask leading questions. But generally speaking, you cannot ask leading questions on direct examination. But you can ask leading questions. Well, on cross-examination, there are no rules as to what the form of the question is. There's no prohibition on leading questions. So on cross-examination, you always want to ask those leading questions, which are questions that suggest what the answer might be. And the reason that you want to do that is because you want to control the narrative as the lawyer. It's generally speaking going to be a witness who is not in your favor. If you're asking them questions on cross-examination, it's a witness who is called by the other side. So because of that, you want to control the narrative through those leading questions. And you basically, want to put words in the witness's mouth. You don't want to ask them open-ended questions like, why did you do that? Or what did you do next? Because it allows them to control the narrative and basically give a speech about what they want to say there. So I'll give an example of, I'm going to use an example of a custody case where one parent is filing an emergency custody action against the other parent due to their house being in, having unsafe living conditions. So, on cross-examination, if you're defending the person who is basically, the other side is claiming that they have unsafe living conditions in their house, you will want to ask the opposing party leading questions. You might want, to give an example, you say, well, you went and you saw the mother's house on Wednesday, May 5th. Isn't that correct? And what you observed, you thought to be unhealthy living conditions. You saw mildew on the windows, correct? And you saw mouse droppings on the floor. Isn't that correct? And you took that to mean that my client isn't keeping proper care of the house. She isn't taking steps to ensure proper living conditions for your daughter. Isn't that correct? But for all you know, she could have been contacting the landlord every day to help with the mildew ever since the first day it appeared. Isn't that correct? And she could have had an exterminator at the house every single day ever since those mouse feces first appeared at the house. Isn't that correct? And that could have been a very recent mouse infestation that she has been addressing ever since the onset of when it first appeared. Isn't that correct? So in that scenario, you are controlling the narrative and you're using it to kind of poke holes in their argument of the unhealthy living conditions in the house. So that's the first main rule of cross-examination. Always ask those leading questions so that you can control the narrative. And the other basic rule of cross-examination is that you only ask questions that you know the answer to. So if you don't know that they haven't, if you know that they have been speaking with the landlord and that the landlord, might know of the mildew and it's not their responsibility, you certainly don't want to ask the question of, well, she could have been contacting the landlord every day to help with the mildew. So you only ask questions that you know the answer to, or at least you have a pretty good idea of what the answer is. If you're pretty sure they haven't talked to the landlord, or maybe you'll ask a preliminary question of, well, have you When's the last time you had communication with the landlord? That preliminary question can kind of give you the information you need. It'll tell you the answer so that you can ask that follow-up question of, you don't know that she's been contacting the landlord every day about the mildew. That gives you license to ask that follow-up question because it tells you the answer. So a famous example of this, you may remember it, is the O.J. Simpson trial, when the prosecution asked O.J. to try on the glove on his hand, and it ultimately ended up not fitting. So that was a not too smart move by the prosecution, and they violated the rule of only ask a question that you know the answer to, because clearly they did not know that the glove was not going to fit on his hand. And that's where the famous line of, if the glove don't fit, you must acquit, comes from. So an exception to the rule of never ask a question that you don't know the answer to is if you don't care what the answer is. So in the custody scenario, at the end of testimony, you might ask a question to the effect of, well, you would feel pretty bad knowing, you would feel pretty bad about bringing this custody action, this emergency custody action about the unsafe living conditions in my client's house if you came to learn that she's actually been contacting an exterminator and the landlord every day since these problems first came to the surface. Well, you don't know what the answer to that is. They may feel really bad about bringing the custody action. They may not. But it doesn't matter. You're just trying to get the judge to hear what the question is and essentially make a point of, well, that's a pretty crappy thing to have done to bring this emergency custody action without first maybe trying to have a conversation with my client about what's going on. So those are the basics of cross-examination, that you only ask leading questions so that you can control the narrative, and then make sure you only ask questions that you know the answer to, unless, of course, you don't care what the answer is. So if you have any other questions about cross-examination or anything else related to divorce or family law, feel free, as always, to give our office a call, and we would be happy to answer any questions that you have.